We're here on a motion to enter and dueling motions for reconsideration. Is that correct?
Yes, Your Honor.
That is correct.
If you want me to reconsider something because of new evidence, I guess I could decide whether I'm going to let you do that, and then we need evidence, right?
Great. I have Ms. Rothis available to testify at 3 p.m. today, Your Honor, briefly on some of the things that happened during the summer possession and some of the things that have come out during therapeutic work that she's done with the children that I think goes and speaks to the issue on my client's request that Ms. Linton have the traditional standard possession schedule instead of the expanded. And then I have Mr. Linton present to testify about the decision of the Travis County Appraisal District, Central Appraisal District's ruling on the rental property Flying J was valued at $980,000, which is considerably less than the amount that was on the spreadsheet by the parties. The parties had agreed to use the TCAD value because we couldn't have the property appraised. It's now made a $170,000 adjustment. And so we are asking the court to take that into consideration.
But probably based on a protest that wasn't heard and decided before I had this trial. Yes or no?
That is correct.
I'm not going to do that. Just like when I was in y'all's position, I tried a lawsuit and 6 months later, somebody said, I'm trying to sell it. It doesn't sell for that much. Markets changed. It could have gone up 100,000 in 2 months. It could have gone down. Ms. McClyman, so y'all agreed to use that value. I'm not going to reconsider that because he had a successful protest. Because furthermore, I don't think usually the appraisal district value, y'all agreed to it, is usually not right anyway. It's usually lower, but so does that take care of that?
Yes, if the court's position is that it was the gamble, and I understand, Judge.
If it's new evidence that things that happened after the date of the trial, and y'all agreed, then I'm not gonna. You can't say, King's X behind my back, and if I win this appraisal, protest, I get to lower the value. If I don't remember specifically, but if you're telling me y'all agreed to use what was then the Travis Central Appraisal District value, you're going to live with that.
Right. We were unable to have it appraised. Ted Lear said he couldn't because the property was in litigation. And so he was not able to appraise this particular one. He did the marital residence, but he wasn't able to do Flying J because of that litigation.
No, I understand, but you made an agreement with Mr. Culp. And now you want to change that agreement based on evidence that happened subsequently. And that I don't think is fair, and I'm not going to consider.
Understood. We would like the court to hear from Ms. Rothis, though. Ms. Linton did take the children to California. The children over the summer reported to Dad that they were in Houston the whole time and denied leaving the state of Texas and have made some regressions in the way that they are interacting with Dad. There are concerns that Ms. Linton has instructed the children to not disclose that they were traveling. She also prohibited Mr. Linton from having that phone conversations with the children during that period. He's ordered to have FaceTime once every 48 hours. That was completely denied to Mr. Linton. And so we are asking the court to take that up and consider its position with the expanded standard.
Judge, I'm sorry, can I ask a question? Ms. McClyman, your audio is very low.
I apologize.
Oh, that's so much better.
Ms. Prima could hear it to make a record. I'm okay.
It's fine. It's fine. Thank you.
Okay. All right. If there's evidence that I'm pulling up my order. Tell me, did I say anything about calls during visits? Where is that in my letter? FaceTime with the other parent. Okay. Well, if there's evidence that part of my order was not complied with, I will take up that new evidence.
Well, Your Honor, if I may, I think what this seems to be then would be more of an enforcement issue, not what is effectively a modification of the possession and access schedule. The court took 4 days of testimony, heard from all of the professionals that were working in this case, I think with the exception of Tao Fan, and made its ruling not conditioned on anything, but that Miss Linton was going to have an expanded standard possession schedule and was going
Well,
to
let me stop you. You have also filed a motion to reconsider or clarify. You want me to reconsider, or do you want me to set it? You've asked me to do the same thing, haven't you, Mr. Culp? Yes, it's.
I understand, Your Honor. I think the only thing I'm saying is that a fundamental change to the possession schedule, we have some minor changes to the possession schedule that are really, I would characterize more as tweaks. This is more of a fundamental change that they're proposing. But I take your point. I just wanted to make that.
Your point would be a lot stronger had you not filed a motion to ask me to reconsider too. So.
I understand, Judge.
All right. How are we going to proceed? We're going to pull up a draft decree until 3 o'clock. What are we going to do?
Yeah, if I can share my screen, Your Honor, I can start taking the court through our edits.
The court wrestles with Easter and Passover, sparking firm refusals.
Rothfuss, spelled R-O, T like in Tom, H like in hat, F like in Frank, U-S like in Sam.
And Ms. Rothfuss, can you remind the court how you're involved with the Linton children?
Yes, I have been working with them as a reunification therapist, family therapy, since March of 2024.
And after the final trial in this divorce matter, did you continue to treat the children?
I have seen them several times.
Okay. When was the last time you saw the children?
Last week on 8/18/2025.
And who brought the children to that session?
Dad did.
Okay. Did Mr. Linton participate at all in that session?
Yes.
How would you describe the children's interactions with Mr. Linton during that session?
Very quiet, very withholding. When we talked about certain issues, they were very quiet and withholding. Other than that, they also seemed like, they were happy to be with Dad.
Prior to the final trial in this matter, how would you describe the interactions with the children and their father during sessions?
Prior to the trial?
Correct. Like immediately prior to.
Immediately prior to. They were doing okay with Dad. I mean, everybody was getting along pretty well. Before the trial, I think there have been a lot of changes for the children. So they were, trying to deal with a lot of different change that was happening.
When you were testifying at a temporary order hearing in front of Judge De La Yata after the reunification work had been done, would you agree that your testimony was that the children and their father's relationship had been repaired?
Yes.
Okay. Do you have any concerns about the repair work that had been done based on your current interactions or more recent interactions with the children and Mr. Linton?
Yes.
And why do you have concerns?
Well, Mr. Linton called me and asked me to do a session with the children because he had found out during the time that they were with Mrs. Linton on her possession time, they had actually taken a trip to California.
Object to hearsay or, potentially hearsay. There's no foundation for Mr. Linton's personal knowledge about anything that I think anything that Ms. Rothfuss is about to describe right now.
Well, if Ms. Rothfuss has personal knowledge of what the children said in a session where she's treating.
Ms. Rothfuss is limited to what the children might have said. I don't want her testimony to be based on what father told her, which may or may not be based on hearsay.
Ms. Rothfuss, let me ask you a question. Did the children tell you whether or not they went on any trips this summer?
They said that they had gone to Houston, and they did say that they had gone to California.
Did they discuss in front of you or with Mr. Linton in the session their truthfulness to their father about going to California?
Yes,
And what did they state to you?
they said that.
I guess I'm gonna have to object. It's how, I don't understand how those statements need to be linked to a specific treatment of the children. That it has to be, it's not whether or not they were being truthful with their father, but whether or not they are, whether or not that impacts or how that affects their understanding of what they're being treated for.
Well,
It's
there
not
was a,
it's not just any statement that's made in therapy can be repeated. It has to be specific to the treatment.
so she mentioned that there was a regression in the interactions and relationship between the children and the father from where they were after
That
the
objection right now is overruled. Go ahead.
Okay, Ms. Rothos, you can answer the question.
Can you repeat the question?
Right. What did the children state in front of you regarding their truthfulness to their father about the trip to California?
They said that he had not asked them directly if they had gone to California. They had only asked him. He had only asked them about what they did during the time they were with mom, and so they did not. Because he didn't ask them directly whether they'd gone to California, they did not say they had gone to California.
Did the children express any concerns about what would happen if they did tell their father that they were in California?
Leah felt like her dad would make her come home early from California.
Did you discuss that with Leah and Mr. Linton in the session?
Yes, we did.
Okay. And were there any other concerns that you had about why they weren't telling, or did the kids explain to you why they weren't telling their father information about what they were doing this summer?
Leah just said that she was afraid that dad would make them come home early from their trip with mom. And so she hadn't wanted to say anything. And Matthew had said that they had been in places where they actually talked to dad. They didn't have cell coverage.
When the children were in California, was Leah baptized?
Leah says she was baptized, yes.
And did Mr. Linton attempt to talk to Leah about that in the session with you?
Yes.
And did Mr. Linton get told, to your knowledge at all, that the child was being baptized?
Objection leading.
You know what? Why is that relevant? They each have the right, I'm like, to direct the moral and religious training of the child.
I agree. It's about what the child shared, Your Honor, with it as to why she couldn't disclose or didn't want to disclose it to her father. So I'll keep it really brief if I can just ask that question. May I ask that
Go ahead.
question, Your Honor?
Go ahead.
Ms. Rothis, what did Leah state about why she didn't tell her father that she was being baptized?
She just said that she didn't feel comfortable talking to him about any of that.
Prior to the summer possession, was Leah willing to have conversations in session with her dad about various disputes?
Yes.
Okay. And were there any other conflicts that you helped work through with the children and their father in this last session?
There were some issues around communication that the children had been upset about when dad went to retrieve their belongings at summer camp. They were angry at him for being there. And we did talk a little bit about that. Dad did discuss that with them.
Did you have any concerns about the type of information that the children had learned about disagreements between the parents over the summer?
I think that the concern was that the children oftentimes got stuck in the middle, like they didn't really know what was happening. And therefore, they often felt frustrated or angry with dad. They felt like he was maybe, intruding on their space or their time with mom.
Nothing further, Your Honor. I'm going to pass the witness.
Mr. Culp.
Yeah, Ms. Rothfuss, you said that the children are still appear to be happy to be around their father. Is that right?
Yeah, they were sitting by him on the couch and kind of, they goof around a little bit when they're in the office together.
Okay. And children being, the kids presumably are talking to dad and talking to you in sessions about things that are kind of difficult to talk about, right?
Sometimes, yes.
Okay. And sometimes that can be difficult for kids, and that difficulty may manifest itself in different ways, right? Being a little withholding, maybe being frustrated, maybe being even angry sometimes, right?
Good, yeah,
And you have to help them work through that, right?
yes.
Okay. And it sounded to me like what the kids were doing was that maybe the children were not being truthful with their father, correct?
It did sound like that, yes.
And that's definitely something that you could work with the children on, like, hey, listen, if your dad asks you a direct question, then you need to be honest and forthcoming about the answer. That's your job as a child, right? To tell your parents the truth, correct?
Yes, we talked about that.
Okay. And you did not testify that that Miss Linton was telling the children to not disclose this information to their father. Is that right?
I did not testify to that.
All right. And so were you aware of, so the issue with the clothing at summer camp, is it your understanding is it your understanding that Miss Linton was really the driver behind Camp Longhorn this past summer, right?
I don't know.
Okay, all right. And it was Miss Linton who picked up the children from summer camp.
Yes, is my understanding she picked them up.
Okay, and that Mr. Linton showed up on the same day and took all of the children's clothing with him in their luggage, even though Miss Linton was taking the children back to her home after camp. Were you aware of that?
That's what was reported to me, yes.
Okay, so it could be that the kids were frustrated with dad because maybe they weren't expecting him to show up and take their clothing, right?
Could be, yes.
Okay. And that can contribute to them kind of feeling like they're in the middle of things, right? They don't know if we're going with mom, why are our clothes going with dad? Maybe, why is dad even here? Things like that, right?
Sure, yes.
Things that could have been communicated by Mr. Linton to the children. I'm not sure if they were or not, but that's something that could have been, and those are things that you could have addressed and can address with Mr. Linton and the children together, correct?
Yes.
And you haven't listened to any audio recordings or video recordings since trial?
No.
Of the family? Okay. And obviously you haven't sat in the home with Mr. Linton and the children or anything like that. Your contact has been limited to sessions.
Correct.
You haven't spoken to Miss Linton about any of these issues, correct?
No.
Pass the witness.
Ms. Rothis, were you aware that Miss Linton's possession for the summer was on the same day that the Camp Longhorn program ended? That it started the same day that the camp was ending?
Yes.
Okay. And were you, did you specifically ask the children if they talked to their dad while they were on the trip in California?
The children told me they did not talk to their dad while they were on their trip in California.
What did they specifically say when you asked that question, if you recall?
Matthew said they were in places where there was no cell phone coverage, that they couldn't speak to him. Joshua didn't respond. Leah didn't really comment.
How would you describe the children's demeanor when you were having that conversation with them?
They seemed shut down, very guarded. Just like they weren't sure they wanted to say very much.
Okay. How would you describe Leah's affect when you approached the California topic?
She seemed very hesitant to speak about it or say very much of anything about it, but also worried that dad would have made her come home early.
Okay. Nothing further. I'll pass the witness.
Nothing further, Your Honor.
May this witness be excused.
Yes, Your Honor.
Yes.
Thank you, Ms. Rothfuss.
Tension rises as lawyers argue if grandparents can attend events.
Mr. Linton's separate return. And because of that $166,000, he had an additional $61,000 of tax liability that he had to pay. And so we would ask that the parties, that it remain as the court ordered.
Well, Your Honor, Miss Linton also had to liquidate, I believe it was very close to $100,000 of her own 401k in order to pay legal expenses before the interim, the last major interim fees order in the case, which was, I think, back in January of this year, is when that was, either December of last year or January of this year, I think. And so I think both parties had to liquidate their own retirement accounts to fund that litigation. And so that's why we're asking for that just to, and again,
Well,
they filed separately, so.
Well, not by choice.
Hold on. Let me make sure I'm following you. Were we talking earlier about Miss Linton claiming she has something less than $18,000 in tax liability for 24, right?
2024, yes, ma'am.
They filed separately for 2023.
Correct.
Yes, because Miss Linton wouldn't agree to file jointly. And she,
That's
and
why on my ruling, it was.
And the tax returns aren't done correctly anyway, because under the law, it's a community property state. Half of Mr. Linton's income should have been filed on Miss Linton's 2023 separate tax return because it's a community property state. And she didn't do that. So I would like it to be 50-50 liability on both ways.
As I understand that, Your Honor, is that is a technical rule,
Yes.
but the CPAs that I've spoken with have said that that's hardly ever enforced, if it ever has been.
But it is the law. I understand that. Most people can file. It is the law.
Well, I get that. I understand, and I'm not trying to.
But I don't think the
if
court
we're going to
can.
go back through and scrutinize everybody's tax returns after this has already been after the court's already divided everything up. I mean, we're talking about a $10,000 swing here.
Well, here, hold on. Has his 2023 taxes been paid?
They have
Yes
been paid.
or no?
Yes.
That's why I did it the way I did it. They were paid. There was less community estate. So essentially, she paid part of it already because otherwise there would be more money in the community estate. Yes or no?
That's correct. That's why I put it on my spreadsheet the way that I did, Judge, and I didn't put it as a debt because it had already been paid out of community funds. But my point is, I don't think the court can change. What Mr. Culp was asking me to do is to have us not follow federal law, and I don't think that we can agree to do that in the decree. So I would ask that for prior years that it's just split 50-50 between the two parties and we leave it at that.
But they both already filed separate 23 and 24 returns. Yes or no, Ms. McClyman?
That is correct.
And they both already did it the wrong way. Yes or no, Ms. McClyman?
Correct. But if the federal government comes back to address that.
Well, surely if somebody turns them in, you're right about that. If the federal government brings it in, but y'all have now made this so much more complicated than it was when I tried this case for 4 days in June. And I apologize if my fuse is a little short. I've had a really rough couple of weeks. But I'm looking at my spreadsheet. His 2023, I'm not going to change my orders. The only thing I might consider, if Mr. Culp can, by Wednesday, because I put his tax liability, I put his liability for 2024 on there. If she can get something that substantiates what hers is, I may consider that. I'm not going to go back and redo 2023. I guess that argument should have been made at the time of trial that they filed wrong. And I mean, I can't order them how to file their taxes anyway, as we all know. That's a federal matter. And yes, Ms. McClyman, I think you are correct that as a technical matter, that's, everybody should report half the income and half the liability. But they chose to file separately. They didn't choose from all the times they were in court to come back to court to say, this is how we're going to do 23 or 4, ask a judge to make an order that she report half the income. So I'm not going to make that change.
I would just ask the court to consider that she could have chose to withhold tax when she got that distribution from the retirement and she chose not to. And now my client's going to have to come up with the money to
That's why,
cover that.
hold on. That I don't know if it's from the distribution or I don't know if it's from her income that she didn't withhold the money. I have no idea. There has not been any good evidence. I'm giving her a little bit of time. That should have been presented at the time of trial. I mean, maybe the evidence was, and forgive me if I don't remember because I slept and tried about 35 cases since then, but I don't know what it's from. But what does he have the big tax bill for? Huh?
From selling
Just
all of the stock to give her money for attorney's fees.
okay. And it maybe she sold hers to get money for attorney's fees. So why aren't those two things the same?
Well, he did withhold though when he was getting distributions so that their tax liability wouldn't be as great. And that was just my point, is that now he's having to pay more
Well,
because she chose not to withhold at the time.
in the grander scheme of this estate and how big it is and how much money we've spent on various things, first of all, I don't have any good evidence. I've given her a very short time frame to show you, and you can bring it back to me and then I'll decide, but I'm not going to decide that today. All right, what else? We need to hear from the parties.
Do you want me to proceed first, Judge, with calling my client? Or
Sure.
do you want, okay.
Mr. Linton, would you please unmute yourself and raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
All right, Mr. Linton, would you state your name for the record?
David Elliott Linton.
Okay, Mr. Linton, since the court made its ruling in June of this year, how would you describe the electronic communications with the children while they were in possession of Miss Linton?
All electronic communications have been very challenging the last 3 months.
Have you communicated desires to speak with the children?
Oh,
while...
yes. Yes, and I've not been able to have regular communication with the children while the children were in Ms. Linton's possession.
Has Ms. Linton accused you of not making the children electronically available to her?
She has.
Okay, and is that accurate?
No.
And Your Honor, may I share screen with the
Yes.
court? Okay.
Money on the line. Judge rejects house sale and tax fights erupt. This financial showdown exposes just how high the stakes really are.
Yes, I can.
And this has been pre-marked as Petitioner 7. Did my office export the OFWs between you and Ms. Linton since the trial in May?
Yes.
And is this 300-page document a true and accurate copy of the communications between the two of you since that time?
I believe so, yes.
Okay. Your Honor, I'd ask that Petitioner 7 be admitted.
No objection.
I'm sorry, is it admitted, Your Honor? I didn't hear.
Yes, I'm sorry. It's admitted.
Okay, thank you. Now, Mr. Lynn, just yesterday, can you explain what happened to the court and what you were attaching to your communication?
I had been accused of earlier in the communication of not making the children available for phone calls. That's the opposite of the reality. And I just responded that Ms. Linton does not accept incoming phone calls on a regular basis. So I don't know what to do. And I included an attachment, a picture from earlier that day, or earlier that evening, when we tried twice to call Ms. Linton with the children.
Okay, so just so it's clear, you're helping the children facilitate calls. They're not being accepted. And then Ms. Linton in response is sending communications saying you're not making the children available. Is that right?
That is right.
And does
Yes.
OFW log all of that type of activity?
It does.
Okay. And in regards to summer plans, did you reach out to Ms. Linton to know if she was traveling with the children?
Yes, I did.
And how would you describe her willingness to tell you where they were?
She did not. She just said she'll reach out in case of emergency.
Right, I'm showing page 223. Uh, is that communication you just referenced?
Yes, yes, it is.
Okay. And when you're asking Miss Linton to speak with the children, how many days does Miss Linton typically go before reviewing or responding to your questions?
It varies. I think the average is around 2 weeks, but it could be 1 to 3 weeks.
Okay. And let's see. Did you ask Miss Linton if she wanted to have additional time with the children at the beginning of the summer, immediately following the court's ruling?
Yes.
And what were the terms of her willingness to have additional time with the children?
So originally, slightly prior to this, the portion of the conversation you're showing, I asked Miss Linton if she cared to watch the kids for 4 hours on one of either 2 days, and she agreed to a day. And then a couple of hours before the agreed upon time, I think I was dropping the children off between noon and 1. I received this note saying that she wanted $320 in cash and another $1,000 using OFW Pay. And she seemed to suggest that if I didn't do this, that she was going to involve the children. And I didn't know what to do.
The court has ordered that you both have electronic communication with the children every 48 hours. Uh, how long did you go without talking to the children this summer?
There was probably a 2.5 week stretch when I did not speak with the children,
Okay, and
and they
then
were in. Yeah,
can you explain to the court what happened at the Camp Longhorn pickup?
yeah, yeah. So, by way of quick background, Ms. Linton set the summer schedule all the way through August, or the beginning of school. I had informed her at the time that I wasn't comfortable with the end of the schedule because it was unclear who would pick up the children, and I would not have much time with the children before school started. Oh, yep, that's it. It's where but I agreed to follow it because I thought that we were going to finalize all the terms by middle of July. When that didn't happen, I still did my best to stick to the summer schedule that Ms. Linton had provided. And in the schedule, it showed change of possession at 8 a.m. on, I think it was a Saturday or Sunday, I believe Saturday. And the cars are supposed to queue starting at 6, and the gates open between 8 and 8:30. And following the schedule, I wouldn't have the children until right before school started. And I tried communicating with Miss Linton beforehand about picking up the children's items. I reached out to Miss Nixon to see if there was a way that we could work together to figure out this possession change. And I was unable to. Ms. Linton didn't respond to my notes until after the pickup. When I
Right.
arrived at the yeah.
So just to be clear, so the court on the second page of its ruling had instructed Miss Linton to resubmit her summer dates, right?
That is correct.
And she did not do that, did she?
She did not.
Okay, so you were left with the possession schedule that Miss Linton had dictated prior to the final trial, correct?
That is right.
Okay, so you still showed up when Longhorn, the last day when the children were being released, correct?
That is right. Yep.
And did the children have specific things and items from your home that they decided to take with them because you packed all of their summer trunks?
Oh yeah, uh, uh, lots of clothing, and they all chose to take their own bedding with them. Each child has 2 sets of sheets, and I had to send the children with 2 sets of sheets. And so all of the bedding that the children would have went with them from my house to their camp.
Okay. And so you went and retrieved the trunks,
Mhm.
correct?
That's right.
And you notified Miss Linton that you were going to do that before you appeared, correct?
That's right. Yep.
It wasn't a surprise to her, right?
That's right.
Okay. But did she act surprised in front of the children?
Yeah, she began yelling at me, telling me she took out her phone. She started recording me.
Objection, non-responsive.
Oh, can you please re-ask the question?
I didn't know if I heard a ruling from Judge Mossy. I apologize
I
if it cut
said
out.
overruled.
Okay. So Mr. Linton, how did Miss Linton react when you appeared at Camp Longhorn?
Very hostile, very aggressive. She raised her voice just below the threshold, I think, of yelling. She took out her phone, began recording me, instructing me that I wasn't allowed to be there. The kids weren't allowed to spend time with me because it's her possession.
And you mapped out all of this to Miss Linton 2 days prior to camp ending, right?
That is correct.
But she didn't log in to review this for 2 days until the incident had already occurred, right?
That's right.
Are there other issues that have emerged because Miss Linton doesn't check our Family Wizard consistently?
Oh yeah, it's very challenging.
And are you asking the courts to modify the standard possession schedule just to the traditional times so that you're not having to navigate exchanges with her more frequently?
Yes.
Okay. And do you think that it's in the best interest of your children that they have less overnight possession with their mother?
Yes.
Have you noticed any type of regression with your interactions with the children since they had that extended time with their mom over the
Yes.
summer?
Yes.
Your Honor, I'll pass the witness.
Mr. Culp.
Mr. Linton, you said that you think it would be better to minimize exchanges between you and Miss Linton, correct? That was what you just testified? Children's best interest to have to go through, correct? You agree with me that it would be better, as you just testified, that less exchanges with you and Miss Linton would be better for the
Yeah.
children, correct?
Yeah. May I clarify my prior reading?
No, just yes or no, Mr. Linton.
Okay, then yes, fewer exchanges are better.
And while the children were on their summer trip with Miss Linton, you did have phone calls with them, correct? Or some sort of electronic communication with them, correct?
While they were in California, I did not have any communication with them. No.
And what dates were they in California?
I'm not sure.
Okay. And so did Miss Linton did not try to FaceTime call you during that time period?
No,
Or initiate
zero.
FaceTime calls?
No.
Okay. Did you try to call her or FaceTime her?
Yes.
Okay. With the Camp Longhorn thing, under the schedule or under the modified schedule that you and Miss Linton had been working off of, or what your assumption was, it was your understanding that Miss Linton was going to take the children from Camp Longhorn and take them back to her house when Camp Longhorn concluded, correct?
Yes.
Okay, all right. And so you could have just allowed, and how long after the Camp Longhorn was going to end was Miss Linton going to have possession of the children before it was your time again?
I'm sorry, can you ask that again? Can you restate that?
I'm sorry. After Camp Longhorn ended, how long was it until your period of your next, how long between the end of Camp Longhorn was it to your next period of possession?
I believe it was maybe 3 days,
Okay.
4
all
days.
right. And where did you guys exchange the kids after that period? Was that at school?
I picked the children up from Ms. Linton's residence.
Okay. And so you could have picked up the children and their luggage from Miss Linton at her residence when you picked them up after Camp Longhorn, right?
I suppose I could have, yes.
Okay. You're planning to continue to work with Miss Rothfuss on these issues that you're having with the children?
Yes, as long as she thinks it's appropriate.
Right. And you think that Miss Rothfuss is helps you work through these issues with the kids, correct?
Yes,
Okay. You've put a lot of faith in Miss Rothfuss's recommendations and her therapeutic strategies for you
yes.
and the kids. Okay. Pass a witness.
Mr. Linton, can you clarify what you believe would be in the best interest of your children as it relates to exchanges with Miss Linton?
Right. When thinking of exchanges, there's exchanging the children, and then there's also exchanging items that are in their possession. Both of which instances cause conflict and are difficult. When the children are with Ms. Linton for extended periods of time, that necessitates more exchanges of items, blankets, clothes, things like that. All of these are problematic. And so the fewer overnight visits, the fewer exchanges as it relates to other items. And so I don't want exchanges to be hard, but they are.
Nothing further. Pass a witness.
There's nothing in the order that about Camp Longhorn going forward beyond summer of 2025, correct, Mr. Linton?
That's right.
Nothing further, Your Honor.
All right, Mr. Colt, do you want to call your client? You're not required to, but given that I let Ms. McClyman call Mr. Linton, I'll allow you to call Miss Linton.
Sure. Ms. Linton, if you could unmute yourself.
Swear you in, Miss Linton. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Linton, you heard Mr. Linton testify that you did not make any attempts to contact him or facilitate communication between you and the kids while they were in your possession over the summer.
I did hear that, yes.
Is that accurate?
It is in the
Okay. Did you attempt to, how did you attempt to facilitate communication between Mr. Linton and the children while you were on summer vacation?
Sure. So I tried to follow the order by the T, and the order said FaceTime. So I did not use OFW because the order said FaceTime. And when I was not on data, I would call.
And when you say the order, are you referring to the draft orders that had been exchanged?
I didn't have a draft order, but the letter of ruling.
Okay. So you were, okay. And so relying on the letter ruling, you attempted to make FaceTime calls is what you're saying.
It wasn't clear. I believe the letter ruling said visits over 48 hours, the parent in possession needed to facilitate electronic communication or something to that effect. So it didn't specify if it was once every 48-hour period or just once period for any possession period greater than 48 hours. So I took the more conservative approach and had them contact him at least once every 48-hour period.
Okay, and how did you facilitate that or attempt to?
Sure. So a lot of times I use my phone, and if we had data, I would use FaceTime, and I would hand the phone to the kids and make sure that they connected. And then when they were finished, I would have them pass to a sibling and then pass to the other sibling, and then they would bring it back to me whenever they were finished.
Did you at any point instruct the children not to disclose the location, their location to their father on your summer vacation?
I did not.
Okay.
When school would resume, correct? On August 12th.
No,
Well, August 9th through August 12th is when you asked to have possession of them pursuant to that swap, correct?
those dates are correct, yes.
Okay,
That's not when school resumes.
but your possession time was not just 2 increments, correct? You selected 3 separate summer periods, right?
Which time are you speaking of? Because I
Well,
had to redo the schedule following the trial, so I just want to make sure I understand your question.
right, following the trial on June 4th, you selected June 16th through July 2nd, July 15th through July 22nd,
Mhm.
and July 27th through August 2nd while the kids were at camp, right, for 7 days during camp time. And then you had that August 9th through August 12th, correct?
I have to look at the calendar.
Okay. Why did you not agree to Mr. Linton coming to Camp Longhorn in order to retrieve the children's property?
Well, the order had stated that a parent was enjoined from attending any of the kids' extracurriculars when they are on the other parent's time. So Camp Longhorn, the gates open at 8 o'clock, which is when my possession time started. So following the order, he wouldn't be able to be at Longhorn for that, and we had discussed that when we made the swap back in May.
But Camp Longhorn is the end of his possession period, correct? His possession period would have ended August 9th. Is that right?
It ended at 8 a.m. that morning, and mine began at 8 a.m.
Okay, is that the day of pickup?
It is.
Okay, so the same day as pickup at 8 a.m. when parents are allowed in the gates, correct? Mr. Linton was present to take possession of the trunks. Is that right?
I don't know where he was.
Did you see him?
I did.
Okay. And it wasn't, camp was dismissed at that point, right? It was no longer an extracurricular activity for them.
Sorry, I don't understand the question.
Well, you're saying that because it was an extracurricular activity, he wasn't supposed to be present, right? Is that your position?
So the camp gates open at 8 o'clock, but there are activities, scheduled activities at camp until I believe it's 11:30 or 11:45 that morning. So yes, camp is still in session until they close the gates, I think at 11:30 or 11:45.
Do you believe that camp is an extracurricular activity? Is that how you're defining it?
I believe so.
Okay. Did you have the children call Mr. Linton to complain about him having their trunks?
No,
How did you have the children call Mr. Linton when they were in California?
on my phone.
Through our family wizard?
No, because the ruling had stated FaceTime. But I specifically did not use OFW to comply with that.
And so is it your position that FaceTimes, that you have evidence of FaceTimes occurring between the children and Mr. Linton?
I'd have to dig it up. I'm not handy.
Well, how many times did you have the children call him?
I had them call him at least once for every 48-hour period because I was complying with the rule.
Were you present or observing the children having those calls?
So I would dial it and make sure it connected. And once they connected, I would hand the phone to the child.
Once the FaceTime connected and you saw Mr. Linton, you would hand the phone to the child?
Yes, or if we were on data and there wasn't FaceTime when the call connected and I saw that there were both parties on the line.
Have you, did you tell the children or instruct the children not to tell Mr. Linton that they were in California?
I didn't.
Did you tell Mr. Linton before Leah was baptized that you were having her baptized?
No, it was a snap decision on her part. She decided that's something that she wanted to do, and I helped her facilitate that. It wasn't premeditated.
Okay, when did you tell Mr. Linton that she had decided to be
Miss
baptized?
McClyman, that, no, I'm not gonna go there.
It's
She
just
has the ability to do that.
right, but she also has the requirement to share information with the other parent so that he's not maybe caught off guard when the child's saying something to him.
I mean, there's enough bad behavior to go around, and I'm gonna shut some of this down. I didn't.
I'll pass the witness, Your Honor.
Nothing further, Your Honor.
I'm adding some additional orders. I'm clarifying based on some testimony I just heard. The 48-hour getting in touch with the other parent is by FaceTime or any other electronic means. Ms. Linton, I'm sorry, I don't believe your testimony. And the order will say, and if you don't get the other parent, you must follow up with an OFW message saying what time, when, and how you tried to reach the other parent. And I'm going to include the language, if anybody travels out of state, you must notify the other parent. Based on everything I heard today and everything I heard before, Ms. Linton, I think you intentionally didn't tell him. And if you didn't tell the children directly not to tell him, I believe you certainly gave them that impression. Also, I want to add that both parents are required to give Ms. Nixon releases to speak to any and all professionals treating the parents or the children in this case. And to ensure that my order is being followed, I'm ordering that there be a review hearing with Ms. Nixon present before me from sometime between mid-November and mid-December. And if orders aren't being followed, if somebody has the correct pleadings, I'll be happy to modify them. But I'm going to give people a chance. I don't know. Maybe that's foolish. I'm not ordering the piano. You have until 5 o'clock tomorrow to send me something about the tax return. I'm not going to change the exchange time from holidays. I do think, I thought about this a lot. And Mr. Linton, I hear what you're saying about trying to cut her down on standard possession order to a standard possession order. I think it's going to cause more conflict because I think there will be more conflict if you have more direct exchanges. Any damage she wants to do or continues to do can happen whether she has Sunday night or Thursday night, which is part of why I'm going to have a review hearing. And if things go poorly and there's a proper pleading, I may very well be willing to change the expanded standard to a standard possession. I hope I am heard loud and clear. I expect there to be compliance with this order. I expect there not to be this, the order said FaceTime, so that's how I did it. Be interesting when we have the review hearing, or maybe it in Ms. Nixon, that you come up with your phone records to show that there were FaceTime calls placed, Ms. Linton. These children need to be taken out of the middle of this. I'm sure you're unhappy with me and the way this went, Ms. Linton, but your behavior is distressing. All right, anything else I need to, I think I wrote down everything else I needed to rule on. Counsel, did I miss anything?
No, Your Honor.
I have nothing further, Your Honor.
Okay, you've got till 5 o'clock Wednesday to get some documents to me and Ms. McClyman, and I want a decree entered by Thursday.
Oh,
yeah.
I apologize. Mr. Linton was trying to give Miss Linton $24,000 that she was ordered to have, but she refused to give him wiring instructions so that he could give her that money. Can we just have the decree state that Mr. Linton will remit the funds to Mr. Culp and then he can get them to his client?
Or that Miss Linton can pick them up from your office. If she doesn't want to give wiring instructions, then she has to go travel to get them.
Understood.
Yeah, Mr. Linton can mail them to Mr. Culp if there are not wiring instructions. And then Miss Linton can go get it and go have to cash the check. Anything else?
No, Your Honor, thank you.
No, Your Honor, thank you.
All right, again, by 5 o'clock on Wednesday, I'll make a ruling on that tax issue that could change some of the numbers. In the meantime, y'all go ahead and get everything but that done on the decree. So including, and I went pretty fast. Nixon's the issue about the parent facilitator, I want to add that parents are required to sign releases so that Ms. Nixon can speak to any and all professionals involved in this case. I want to add that I will hold a review hearing between mid-November and mid-December. You two, council, get together and let me know what date we're going to have that and make sure Ms. Nixon's available. Modify my earlier ruling to require the communication for periods of possession more than 48 hours to be by FaceTime or any other electronic means. And if you're not able to get hold of the other parent, you are required to send an OFW message stating when you tried to call, how you tried to call. And that way, if it's not happening and there's enforcement that has to be brought, there'll be specific language to on which an enforcement could be granted. And there's going to be notice of out-of-state travel. It is reasonable that any parent would know when their children travel out of state. If for no other reason than an emergency, God forbid there was a car wreck or an airplane wreck or something, I'm sure Miss Linton would want to know if Mr. Linton were traveling with the children out of state. It works both ways. Anything
Understood.
else?
No, Your Honor.
No, Your Honor, thank you for the
You,
clarification.
you may be excused.
Thank you.
Cross-examination corner. Dad admits fewer exchanges are better. Lawyers press hard, pinning contradictions in a tense courtroom clash. And that wraps up today's breakdown. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.